Okay, good day. Welcome again to the continuation of the series of lectures on persons and family relations. Our topic today is absence. Okay. Um, Article 381 of the Civil Code states that when a person disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer her property, any interested person, relative, or friend may appoint a person to represent him in all that may be necessary. Okay, so it gives a remedy, okay, to the spouse or to the creditors of the person who has not been seen in his place of residence without leaving any agent to administer his properties, to take anything which is any action which is necessary in order to address, for example, the needs of his family or anything that is necessary to protect his property. Okay. So the appointment shall specify the powers, obligations, and remuneration of his representative, regulating them by the rules concerning guardians. So there is also a preference stated in Article 383 of the Civil Code stating that the present spouse shall be preferred when there is no legal separation. So in the appointment of the guardian over his property, the present spouse shall always be preferred. So, however, if he has no spouse, then any competent person may be appointed by the court. It may be his relative, his parents, for example, his siblings, or even creditors because they are interested in the protection of the absentee's property. Okay. So, what is the period of years that is needed in order for a person to be declared as an absentee? So, Article 384 states that 2 years having elapsed without any news about the absence or from the receipt of the last news, and 5 years in case the absentee has left a person in charge of the administration of his property, his absence may be declared. So you have to wait a period of for a period of 2 years to elapse without any news having received from the absentee, or 5 years in case he has left or appointed a person to administer his property. Okay, who are the persons who has the right to file a declaration of absence? The spouse present, again, the spouse is given with respect to the person who will be charged to administer the absentee's property, the heirs instituted in a will, the relatives who may succeed by the law of intestacy, and those who may have over the property of the absentee some right subordinated to the condition of his death. So, a classic example would be creditors or the legatees in a will. Okay. So, the judicial declaration of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. Okay. Now, uh, Article 388 states that the wife who is appointed as administrator of the husband's property cannot alienate or encumber the husband's property or that of the conjugal partnership without judicial authority. So, if a person is appointed as administrator of the appointed of absentees property, okay, the powers of the administrator is only with respect to the management of the absentee's property. That administrator has no right to dispose or encumber the absentee's property unless there is judicial authority. So unless there is consent that is given by the court. Okay. The administration sees. Okay, of course, when the absentee appears personally or by his agent, when the death of the absentee is proved and his testate or intestate heirs appears, okay, and when a third person appears, showing by proper document that he has acquired the absentee's property by purchase or other title before the absentee has left or has been absent or has been declared sick. Okay? Okay. Presumption of death. Okay. So after an absence of 7 years, it being unknown whether the absentee still lives, he shall be presumed dead for all purposes except for the purpose of succession. So you must remember the absence of 2 years is needed for the absentee to be declared as an absentee. For the spouse present, a relative, or a creditor, to be clothed with the authority to file a petition for the declaration of absence. What if the absence of the missing person has been for a period of 7 years? So if he has been absent for a period of 7 years, he shall be presumed dead for all purposes except for the purpose of succession. So there is already a presumption of death. By operation of law, there is already a presumption after he has been absent for a period of 7 years, okay, that he is dead, except for the purpose of opening his succession and except for the purpose of remarriage. Okay. In case the spouse present is intending to remarry, the spouse present must still file a petition in court for the declaration of the absence of his spouse, for the declaration of presumptive death, rather, of the absent spouse. Okay, it is not automatic. The presumption of death provided under Article 9, 390 would not be sufficient to clothe the present spouse with authority to enter into another marriage. He has to file a petition to declare the presumptive death of the absent spouse. Okay? For purposes of opening his succession, it is required that the absentee has been absent for a period of 10 years. Okay, however, if the person who was declared as an absentee is already 75 years old at the time of his disappearance, an absence of 5 years shall be sufficient for the purpose of opening the succession. Okay. Now let us go to the instances or cases when there is a danger of death. Okay, so the following shall be presumed dead for all purposes, including the division of the estate among the heirs. Okay, a person on board a vessel lost during a sea voyage or an airplane which is missing, which has not been heard of for 4 years. A person in the armed forces who has taken part in war and has been missing for 4 years. A person who has been in danger of death under other circumstances and his existence has not been known for 4 years. So you must remember that if the absent person, okay, the disappearance of the absent person is in danger of death, okay, then an absence of 4 years would be sufficient for the purpose of opening the succession. You need not wait for 10 years to open the succession. Now, what happens if the absentee appears? Now, if the absentee appears, or without appearing his existence is proved, he shall recover his property and the price of any property that may have been alienated, but he cannot claim either fruits or rents. Okay, let us now go to the cases. We now go to the case of Republic versus Granada. Yolanda met Cyrus while the two of them were working abroad. Okay, they eventually got married and they produced a son named Cyborg. Now, Cyrus went to Taiwan to seek employment. Yolanda claimed that from that time, she has not received any communication from Cyrus. Now, after 9 years of waiting, Yolanda filed a petition to have Cyrus declared as presumptively dead. Now, in various cases involving Article 41 of the Family Code, we have defined what a well-founded belief is. Well-founded belief that the absentee is already dead before a petition for declaration of presumptive death can be declared. Okay? Um, there are four requisites for a declaration of presumptive death: that the absent spouse has been missing for 4 consecutive years, and there is the disappearance occurred when there is danger of death, that the present spouse wishes to remarry, that the present spouse has a well-founded belief that the absentee is dead, and that the present spouse files a summary proceeding for the declaration of presumptive death. While her brother Diosdado testified to having inquired about the whereabouts of Cyrus from their relatives, these relatives were not presented to corroborate Diosdado's testimony. She should have sought information from the Taiwanese consular office from the government agencies in Taiwan. She could have utilized mass media, but she did not. In other words, the well-founded belief must be based on active search of the missing person. Okay, we have the case of Machas versus Republic. This case is very important because it teaches us that you only filed a petition for declaration of presumptive death if you are intending to remarry. If you are not intending to remarry, then there is no need for a declaration of presumptive death. Okay, so we have a case here involving claim for death benefits of her missing husband, who has been missing for more than 3 decades. So the petitioner filed a petition for declaration of presumptive death. The Supreme Court said that the petitioner was not seeking the declaration of the presumptive death of Wilfredo as a prerequisite for remarriage. The same was filed not for any other purpose, but solely for the purpose of claiming death benefits. Since the petition merely seeks the declaration of presumptive death of Wilfredo, the RTC should have dismissed the petition outright. A petition whose sole objective is to have a person declared presumptively dead under the Civil Code is not regarded as a valid suit, and no court has any authority to take cognizance of the same. So if your purpose is not for remarriage, the presumption provided by the code, meaning if a person has been missing for a period of 7 years or for a period of 4 years, if there is danger of death, that is already sufficient, for the purpose of claiming the death benefits, the presumption provided in the law. The only requirement for a person to go to court and have him declared presumptively dead is when you're intending to remarry. If you're not intending to remarry, then you can claim the presumptive death provision provided under the Civil Code. Articles 390 and 391 of the Civil Code merely expresses rules of evidence that only allow a court to presume that a person is dead upon the establishment of certain facts. Okay. An action brought exclusively to declare a person presumptively dead under either of the said articles actually presents no actual controversy that the court could decide. A court action to declare a person presumptively dead would be unnecessary. The presumption in the said articles is already established by law. Okay. Next case, we have the case of Republic versus Tampus. Okay. It was found that Dante left the conjugal dwelling sometime in 1975, and from then on, his wife, Nilda, never heard from him again. Okay, since his last assignment was a combat mission, and he has been absent for a period of 33 years, it is already sufficient to give rise to the presumption of death. Okay, however, the Supreme Court said again that there is a need for a well-founded belief that the prior spouse was already dead. Well-founded belief requires the present spouse to prove that his belief was the result of diligent and reasonable efforts to locate the absent spouse, and that based on these efforts, he believes that the absent spouse is already dead. It necessitates exertion of active effort, not a passive one. So Nilda testified that after Dante's disappearance, she tried to locate him by making inquiries with his parents, relatives, and neighbors. Unfortunately, they also did not know where to find him. Other than making said inquiries, Nilda made no further efforts to find her husband. She could have called the AFP headquarters to request information but failed to do so. She did not even seek the help of authorities of the AFP itself in finding him. So the present spouse's bare assertion that he inquired from his friends about his absent spouse's whereabouts was found insufficient, as the names of said friends were not identified in the testimony nor presented as witness. Okay, so we now go to the case of Reyes versus Alejandro. In this case, her husband has been absent from the conjugal dwelling since April 1962. Now, her only purpose is in filing the petition is to establish the absence of her husband. So the lower court dismissed the petition on the ground that since the husband did not leave any properties, there was no necessity to declare him an absentee. So the moral of the story, as pronounced by the court in the case of Reyes versus Alejandro, the only reason for the wife to file a petition for declaration of absence is if the husband has left properties that has to be administered. Okay? If there are no properties left by the husband, there is no need to file a petition for declaration of absence. The need to have a person judicially declared an absentee is when he has properties which have to be taken care of or administered by a representative appointed by the court. The spouse of the absentee is asking for separation of property, or his wife is asking that the administration of all classes of property be transferred to her. The petition to declare the husband an absentee and the petition to place the management of the conjugal properties in the hands of the wife may be combined and adjudicated in the same proceeding. Okay? We now have the case of Noquera versus Villamor. Okay? Daya Tol alleged that since she was the acknowledged natural child of Remigio, who had been missing since 1984, she claimed that a certain Diosdado Tol fraudulently secured a free patent over Remigio's property and obtained title thereto. She was seeking the administration of the absentee estate in order that she could recover the said property. Of course, the petition was opposed by Diosdado, who argued that Daya was not an acknowledged natural child and that the property sought to be administered was covered by an OCT issued in his name. So the trial court dismissed the petition. Okay, however, the Supreme Court said that the petition was not a collateral attack on the Torrens title. The alleged fraudulent issuance of title was a justification for her appointment as administrator. But there was nothing in the petition to indicate that the petitioner would attack the title issued to Diosdado in the same proceeding. Whatever remedy she might choose would be pursued in another venue, in a proceeding entirely distinct and separate from her petition for appointment as administrator. So it is not necessary that a declaration of absence be made in a proceeding separate from and prior to the petition for administration. The petition to declare the husband an absentee and the petition to place the management of the conjugal properties in the hands of the wife could be combined and adjudicated in the same proceeding. So the purpose of the rules is the protection of the interests and property of the absentee, not of the administrator. So in this case, what is material is whether she is one of those allowed by law to seek the declaration of absence of remilio and whether she is competent to be appointed as administrator. The issue of whether or not the property titled to Diosdado is really owned by him should be resolved in another proceeding. The right of Daya to be appointed as administrator cannot be denied outright by reason alone of such issue. Okay, so that is all for absence. Thank you for listening and don't forget to subscribe to this channel.